Hey, good morning, everybody. I know that maybe when you guys signed up for this, you wanted to hear Michael talk, but I'm pinch hitting today. So thanks, Dan, for changing the picture in this slide and the name. Uh, and thank you all for joining us today. We're going to do this, kind of I wouldn't say improvisational because I got notes and everything, but more of a, kind of a less structured kind of journey through workers' compensation land. Um, Just as general information, again, this is for educational purposes only. I am an attorney, but I might not be your attorney. If I am your attorney, or if you've subscribed to my HR counsel, you've got questions, please shoot us a question through our portal. This presentation does not create an attorney-client relationship, and it isn't specific legal advice. And workers' compensation is a complex issue. So we're going to provide just an overview here. Again, if you guys are a client and you have questions about things that pop up, shoot it through the portal, please. If you are not a client, but you'd like help with the specific issue in this area or even another area, we'll have some information at the end about how you can sign up. So we can get moving. We're going to jump right into it and talk about workers' compensation basics. So what is workers' compensation? Some people call it workman's comp, some people call it workers' comp, some call it work comp. And I always get confused about where the apostrophe goes, and I have to look it up every time, not gonna lie. But workers' compensation, it's a no-fault system designed to provide benefits to employees that are injured or get ill on the job. It's a type of insurance, and it provides benefits to employees who are injured or become ill due to their job. It covers medical expenses, it covers lost wages, and sometimes rehab or retraining costs, depending on the injury, all in exchange for the employee giving up the right to sue their employer for negligence related to the injury. So that's the key point in this whole statutory scheme of workers' compensation is, and I'll get into this in just a little bit, but in exchange for being covered for your injuries or your illness, no matter who's at fault, the employee gives up the right to sue their employer. And there's some nice things to that, and there's some not nice things to that. I think a nice thing about this is you got cost certainty. You pay work comp. We'll get into the different statutory schemes about captive versus insured. But you are not exposed as an employer to gigantic lawsuits because of a workers' compensation injury. The downside is that if you are, if you are employing someone who does some weird things or some questionable things that causes themselves injured, you still have to cover them even if it is the employee's fault. And that's what no fault means. No fault means that employers don't need to prove, or employees don't need to prove that their employer was negligent in order to receive benefits for their work-related injuries or illness. On the same flip side of that coin, employers can't use employee negligence to defend against a claim generally. So this no-fault system aims to streamline the process of providing benefits and to reduce legal disputes. In a no-fault system, it doesn't matter who caused the accident, whether it's the employee, whether it's the employer, or whether the third party. The focus here is on whether the injury occurred at work and if it was related to the job. If the answers to that are yes, then benefits can be provided to the employee. Workers' comp benefits are usually provided through insurance. There's different work comp laws across the country, and they require some required covered employers to carry workers' compensation insurance. From a private insurer, some allow employers to self-insure under certain circumstances, and sometimes they require payment into a state insurance fund. But again, that last bullet point to me is the key one. It helps limit liability for employees. It takes out the right for employees to sue the employer in lots of instances, and reduces risk and reduces exposure for employers in the long run. All right, who is covered by work comp laws? On the employer side, most employers are going to be covered by work comp laws. Most states have statutory requirements that require private employers with one or more employees to carry work comp insurance. Some states have an exception for small employers with less than a threshold number of employees. And then there's one state, Texas, where work comp coverage is optional. We'll get into that a little bit later, but they still have to pay for injuries. It's just not a requirement to pay into a fund or an insurance policy. Work comp laws typically require the covered employers to carry the insurance, again, from a private insurer, a state fund, or through self-insurance if they're so allowed. All employees, on the employee side, all employees are typically going to be covered by work comp laws. There are certain states and that have certain exemptions from this coverage. Some exemptions might be farm labor. They might be a domestic servant, might be an exemption. Casual workers earning less than a threshold amount. I know there are some statutes in Minnesota that I can't remember off the top of my head, but they relate to whether or not it's a family member of the owner of the company, whether or not they have to be covered or not, or if you're self-employed as the owner and doing work, whether or not you have to be employed too. So there's different rules across the country and across the industry that change who's covered and whose isn't. Volunteers, since they're not employees, they're not workers, so they're not going to be covered under workers' comp for the most part. They're generally ineligible. Some states, like Alaska, provide work comp for some volunteer activities. I don't think we have anybody on the call from Alaska. I haven't had an Alaska question in probably about 4 or 5 months. But if you're in Alaska, there are some exceptions for volunteers where they are covered. And then federal workers. Federal workers are not covered by work comp. Non-military federal workers are covered by the Federal Employment Compensation Act, also called federal work comp. It's a really specialized niche area of the law that I don't know a lot about. And there are people who do nothing but federal work comp law. And actually the first law in the country for work comp at the federal level, and it's still in place, covered railroad workers who are injured on the job. It was passed in the early 1900s. Just before we go to the next slide, we're just going to talk a little bit about the history because I can, and Michael's not here, so I can add whatever I want to his webinar. The first work comp laws, I did some research on this because it's fascinating to me. Actually, believe it or not, were pirates. Pirates and privateers had a statutory system, or not statutory, a scheme, I guess, for if you were injured, trying to kill other people to steal their stuff. If you lost a finger, you lost an eye, you lost an arm, would dictate how much money you got for your injury. The flip side is that you had to survive your injuries, and if you died, you didn't get your money, and there was no benefit for death. There's no death benefit like there is with work comp. The first federal law was the early 1900s, and then a bunch of states tried to pass laws starting around 1902, like Maryland, Massachusetts, New York, and Montana, which does not fit the geographical schema there. But they tried to pass laws very similar to the ones that we have now, where you were required to pay into a fund in order to cover your employees. All those laws were struck down as unconstitutional under due process. And coincidentally, the day after the New York law was struck down, there was a huge fire at a factory in New York, and it was like 140 some people died in that fire or as a result of the fire. And kind of highlighted again the need for some sort of coverage because all the employees' families filed suit against the employer. So you had 146 different lawsuits that the employer had to defend against these families for this fire. And you can imagine the crazy amount of attorney's fees. I bet you the attorney that took that case probably was able to retire off of it if they could defend all 146 cases. But it's just kind of bananas. And then after all those kind of failed in 1911, and so that fire I think was in March or April of 1911, the Wisconsin legislature passed the first one that stuck. So in May of 1911, the governor in Wisconsin signed the first statutory scheme. It was a voluntary insurance scheme. You didn't have to pay into insurance, and that one stuck. And that one was the basis for a bunch of state laws that passed in the next couple of years. I think there were upwards of 40 by the end of 1914. And so it kind of came into being real fast. And these were all kind of based off of a German law. And that kind of makes sense why Wisconsin was on the forefront of that. Wisconsin, for those of you not aware, has a very strong German heritage, as evidenced by all our beer gardens and German names all over the place. But we based our law off the German law, and that kind of stuck and kind of started this process to where we are today. I'm going to skip the rest of history until today because it's relatively unexciting. There's no fires and there's no pirates. So where was I? We just talked about who was covered by work comp, and now we're going to talk about work comp insurance in general. So there's different types of work comp insurance. There's specialty coverage, where workers' comp insurance provides for medical expenses, lost wages, rehab costs to workers who are injured or who become ill in the course and scope of their job. And that's a key litigation part. What is the scope and course of their job? It's different from your regular business liability insurance, for example. The coverage here relates specifically and only to workers' comp, injury, and illness issues. Dan, can you move to the next? There you go. Perfect. The second prong in this slide, liability protection. So in exchange for purchasing these work comp insurance, all employers are protected from civil suits from employees who became ill or injured on the job. So it's a great, bargain. It's a great bargain. It's a great trade-off debate. So in exchange for the requirement of employers to provide work comp insurance, that helps insulate them from certain types of employee lawsuits. So work-related employee illnesses and injuries are covered by work comp insurance. And there's always exceptions. This is the law. Nothing's ever hard and fast because that would be boring and it would give people like me no work to do. But there, an exception can apply if an employer had a high level of negligence and the injury and illnesses went beyond work comp coverage. There's also exceptions, for the employee side too, depending on what they're doing and how the injury occurred sometimes. Just background real quick on work comp insurance rates. Work comp insurance rates are calculated by a base rate set by state and occupation. So, when you fill out those federal forms and you're figuring what your job codes are, that's how they figure out what your rate's going to be. They multiply that base rate by an experience rating. Experience rating, basically, the more claims you have, the higher your experience rating goes, and the higher your rates get. Now, I am not an actuary. I am a fancy law talking guy. I haven't taken a math class since 1995. So this is obviously an oversimplification of how experience rating works, but it's just to give you a good picture of how to figure it out and what it does to your rates. And actually, one last note on this slide before I go forward is and I've seen this before, employees cannot waive liability for injuries that happen at work or work-related events. I haven't seen a single state statute that allows it. If you've ever done a separation agreement with an employee, you'll note in there that there's usually paragraph says I waive any and all claims, except for claims that are unwaivable under the Wisconsin Workers' Compensation Act, or what have you. Because there are some claims that you can't waive per statute. And if you try to waive them, it's going to be unenforceable no matter what the employee signed and no matter how much you paid the employee to sign it. Work-related injuries and illnesses fall under the workers' comp schema, period. Workers' comp can't be waived. I've had several questions in the past from employers who say, hey, I want to hire this guy who's had a back injury in the past, but I want him to sign something that says if he's injured on the job, he waives work comp. And the answer is you can't do that. It's going to be, not only is it disfavored, but it's going to be held to be void as a violation of public policy, and the contract would be unenforceable. All right, we're going to get into the details on state law. So work comp rules are governed by state law. Work comp policy is required, again, in every state except for Texas. And states vary on how many employees you have to have before you do need to have a policy. So for example, California and Minnesota, I can tell you the threshold is 1 employee. In Alabama and Mississippi, and probably some of the less regulated states in the Southern Belt there, you need 5 employees before you have to have work comp coverage. Again, everything is going to vary by state law because this is a state statutory scheme, and so there's 50 of them across the country. All states, and this is not different for Texas, all states require you to report work comp claims to the state or to your insurer. Even in Texas, where you can choose to purchase a policy or you can choose to self-insure and pay the cost if a worker becomes injured out of your pocket, you still have to file and report work comp claims to the state. There are some benefits to private work comp insurance. They're tailored policies specific to business types. I've seen them for construction. I've seen them for, places that will only do office clerical, excuse me. And you'll see some that will be more hands-on when you're dealing with a higher risk type of industry where injuries are higher. You'll get adjusters, or not even adjusters, you'll get help from the insurance company sometimes to review your policies and your procedures and your work to make sure that you're not setting yourself up for claims and you're doing everything you can to reduce risk from the system here. Obviously, with all insurance, you're going to have lower rates for lower risk business. Evel Knievel is going to pay higher motorcycle insurance than I am because I don't jump burning cars and stuff. So the more risky your business is, the higher your rates are going to be in general. Multi-state coverage might be needed if you're doing business in more than one state, or if you're a company that has remote workers and you have people across the country, maybe somebody in Minnesota doing something remote and somebody in Texas, doing something remote, and your main office is in Missouri. You're going to make sure that you have coverage for all those states. And private work comp carriers, can generally do that. There's also the benefit that they have flexible payment options and deductibles, and they're generally a little faster in terms of processing claims. State funds. Some states require employers to purchase work comp directly from the state itself or pay into a fund. These are called monopolistic states for work comp insurance. The 4 that I can tell you off the top of my head about these: Ohio, North Dakota, Washington, and Wyoming. I've had experience with Washington and North Dakota directly, not the other 2 yet. So Again, there's both good and bad to a state fund versus private insurance. In terms of a state fund, the good thing is that there's guaranteed coverage even for high risk businesses. So, Evel Knievel is going to be able to find work comp coverage through a monopolistic state without any questions. Whereas if he is in a private insurance state, he might have trouble finding coverage, or he might be paying astronomical rates. And another good thing is it kind of acts as a carrier of last resort. The state here, the state fund is a safety net. And so you're going to get coverage regardless, and you don't have to worry about it. And the employees aren't going to be left holding the bag when their insurer doesn't have coverage and they don't have any money to pay for them. The bad news with state funds is that they're a state fund, right? And the joke about government being inefficient is, a lot of times true. I used to be a prosecutor. I used to work for the state. So I'm well aware of the inefficiencies within our government system at times, and the lack of agility and the lack of being able to adapt to different situations. So that results in higher rates for some businesses than you would pay on the open market. As with all government things, there's always red tape, so there's more bureaucratic processes. And if you're in a monopolistic state, say you're in North Dakota and you have somebody in, say you're in Fargo and you have an employee in Moorhead, right across the Red River there, the coverage is going to be limited, and you're going to have to find another insurer to cover somebody in Moorhead if most of your operations are in Fargo. So those, there's always two sides to that in terms of figuring out what's better and what isn't. All right, now let's talk about injuries that are compensable by work comp. Number one, and this might seem overly obvious, but an injury has to occur during employment. So covered employees are typically eligible to receive work comp for injuries or occupational illnesses that arise out of and in the course of employment. And that's going to be, the fancy language that gets litigated is arising out of and in the course of employment. That's where a lot of cases come down. That's where some really interesting things pop up. And we'll talk about that just a little bit more in depth on the next slide. Second factor here, second prong, is that the injury has to be the result, or the injury is the result of a workplace injury or illness. Most states are going to require a causal connection between the employment and the injury when determining if it is a compensable injury. But states apply, a different variety of tests to determine whether or not there's a causal connection between the injury and the workplace and whether they were connected at all. And the third prong is that the injury has to result in lost wages or impairment. We can go everything from losing a finger or a limb or an eye to a back injury or a knee sprain or something like that. All those things would be, something that we would talk about. Paper cut, probably not. I got a paper cut the other day. I did not call Mark and say I got a paper cut, submit a work comp claim. That's not something that's there's no impairment and there were no lost wages involved there. A little bit more info on this slide here is that work comp benefits are typically available for the compensable injury as well as the natural consequences of the compensable injury. What that means is that if you have complications that arise from the compensable injury, let's say you break your ankle like I did, and you need surgery to put plates and screws and pins in there. If somebody were to have that happen and then they get an infection that arises out of the surgery, that's arguably a complication from the compensable injury and probably is going to be covered. That's why insurance companies exist. I don't worry about it and I'll let them fight about it. Or also exacerbation of a previous injury or medical condition when the exacerbation was caused by the compensable injury. So let's say somebody had previously hurt their back or their knee or shoulder or whatever, non-work comp injury, and then they are at work and they re-injure it or they aggravate the injury, you're going to be responsible for getting that employee back to the position they were in before they aggravated or re-injured the shoulder or knee or back or whatever it is. And that's a fun debate about where, maximum medical improvement and about whether or not they return to the position they were in before the injury. And that's fun stuff that gets litigated with work comp attorneys and insurance companies all the time. The time limits for filing these occupational illness claims are generally going to be longer for those filing accident claims. And the statute of limitations, again, varies by state. The clock for filing an occupational illness claim often doesn't start running until discovery. So until the disease is diagnosed, you'll see those mesothelioma claims, asbestosis claims. Some of these people were exposed a long time ago and they didn't know that they had any occupational illness because it didn't present until later. In some states, it's not a discovery rule. It's when the employee was last exposed to the cause of the illness or disease. All right. Course and scope of employment. Again, this is where the meat of the litigation regarding work comp stuff comes in. So again, just to rehash, workers' compensation covers illnesses and injuries arising out of and in the scope of employment. So we're going to split that in two. Arising out of, what does that mean? Arising out of is a causal connection between the illness or injury and an employment-related risk. So the risk to this person would not have existed if they had not come to work, or if it's a risk at work, such as a faulty ladder, slippery floor, non-ergonomic keyboard causing carpal tunnel, company vehicle that gets into an accident, et cetera, et cetera. Course and scope of employment has to do with the time, place, and circumstances of the injury. So the question is, did the injury happen within the time and space boundaries of the employer? And remember, a remote worker's job site is your job site. The company car is your space. Doing business at a client site when you send employees to that site now extends the boundaries of your job site and your employment land. And so just a quick example on this, a rather macabre one, but there's we used to work in the IDS Center in Minneapolis. For those of you know where it is downtown, and a worker was clearing snow off of the roof. And in there's a big open, I don't know, courtyard, I guess, but it's enclosed because it's Minnesota and we get tons of snow. A worker was cleaning snow off the roof, and there was a hair cutting salon on the second floor that could see into this big open courtyard space. Atrium, I guess, is a better word. And the worker fell through the glass ceiling, and the stylist at the salon happened to be looking out the front of the business when this happened and saw the worker fall. That worker, the salon worker, the stylist, said that she suffered, extreme mental anguish and distress at seeing this person fall, 3, 4, 5 stories, I don't know how far it was, in through the ceiling. Understandable, that I don't think anybody would see that and say, oh, cool, and go on with their day. So this person was distressed, suffered some mental injuries, and the whole litigation on this case came out to whether or not it was within the course and scope of her employment to be looking out the door, out the front of the salon while cutting people's hair and to be exposed to this type of thing. The case came down that this was not within the course and scope of employment, and so work comp did not have to pay work comp out for this injury. It was an injury. I don't think there's any dispute about that. It's just whether or not it was within the course and scope of employment. And so, these things get crazy in terms of the fact pattern, and there's no way to predict what's going to happen. A lot of times it's going to turn down to a fact finder, be a judge, usually an administrative law judge, to determine whether or not that's within the course and scope of employment. All right, another common litigatable issue is travel or accidents. So travel in a day's work is covered by work comp. So going from one job site to another job site in a company or personal vehicle is going to be covered. So if I start out in the Minneapolis office and I have to travel to the St. Paul office, you know, whether I take the light rail, I take the green line, whatever I take, I drive, I take the bus. If I get injured going from job site to job site, that's going to be covered. If your employee drives a personal vehicle for work and gets in an accident between job sites, you know, again, it's going to be a covered work comp injury. Second prong, all the time spent traveling for business is covered by work comp. So if you have to go to a conference somewhere and you take a taxi to the airport and you are not O.J. Simpson and you trip over the luggage in the terminal, if you get whiplash from a turbulence incident on the airplane, if you slip and fall on the way to the hotel ice machine, if the employee is going out to eat on the business trip and is burned by hot soup in a restaurant. As long as the employee is doing something that they would need to do to accomplish your business, that injury is going to get covered by work comp. And I mean, I probably should have said this earlier, but in doubt, if ever in doubt, just file the claim and let the insurance company fight it out. If they don't think it's covered, great, let them deal with it. It's not your place as the employer to state, yes, this is covered, this is not covered, and you only submit what you think is going to be covered. When in doubt, file. Worst case scenario is that it's covered or not, you know, but if you don't file and it is something that should have been covered, then there's penalties and stuff, and you just don't want to deal with it, especially when you're paying generally a third party to deal with all this stuff. That's what you pay them for. And it's not your job to make that coverage determination. Finally, commuting, not covered by work comp. So if I'm at home and I'm driving into the office and I get hurt on the commute, car accident, whatever, slip and fall on the light rail, you know, bus gets into an accident, I slip on a snowbank on my way to the bus stop, that's probably not going to be covered as a work comp injury. And again, there's lots of litigation around this. The question is, you know, if somebody slips in the company parking lot after they've made the drive to the office, is that something that's going to be covered as a work comp? My recollection is I've seen a lot of cases where that is covered, but again, you don't need to make that determination. That's why work comp insurance exists. Final note on traveling here is that, you know, contrary to, you know, the commute to and from the office, if you say, hey, swing by Home Depot or Office Max and pick up, you know, some printer paper or a hammer on the way to work or the way, you know, way home, and that employee gets into an accident on the stretch of road that takes them out of their way between home and work, that accident is probably going to be covered by work comp. Again, I don't need you to go taking out maps and rulers and drawing lines to figure out whether or not it's between, you know, or if it's out of the way. Submit it to work comp, let them deal with it. Company sponsored events. This is also a fun one. Company sponsored events such as picnics, holiday parties, team building events are going to be covered by work comp. If your employee is required to attend the event, it's going to be covered. So, you know, let's say you take everyone out to the ball game for a day game to celebrate and to do team building and all that fun stuff, and they fall down the stairs at the stadium, that's probably going to be something that's covered by work comp. Even though the purpose of these events is primarily social, and that these events take place outside of your workplace, illnesses and injuries that occur at these events are going to be covered if they are sponsored or organized by the employer. So something being work-related, I guess, is the key here. It's going to be key that it's related to work. It's going to be covered by work comp coverage. We could pick nits all day. Like, let's say I went to a state bar association event that I didn't have to go to, and I was hurt. That's probably not something that's going to be covered. But if my company said, hey, go to the state bar thing and talk to people at this convention or meeting or whatever, that's something that's going to be covered. So again, you can see this gets extremely fact specific, and it can get tricky to figure out which way is up and who's covered and who's not covered. And perfect segue, speaking of what is not covered by work comp, there are some things that are not covered by work comp. Force majeure or act of God, fancy Latin stuff, usually relates to a natural event, wildfire, hurricanes, tornado, earthquakes. We just had I'm in Wauwatosa, Wisconsin. We just had a huge flood down by the river a couple blocks from here. That's going to be an act of God. That's going to be force majeure. It may not be covered by work comp. Work comp generally covers injuries that happen in the course of employment, regardless of who's at fault. We talked about that. So if an employer's negligence or inaction exacerbated injury from an act of God, so for example, let's say there's an earthquake and somebody's injured, probably not covered. But let's say the building's faulty construction contributed to injuries during that earthquake, then we're talking maybe this is a work comp issue and maybe this is covered. Common one-time illnesses. So I know we talk about workplace injuries and illnesses. If I get the cold or the flu or a headache and I attribute it to one of my coworkers, or probably even nowadays, used to never think about this, but if you get measles at work, is that going to be a covered injury? I don't know. That one might be. But common, I think is going to come down to some fun litigation. We'll see. We'll see. Fun, easy for me to say. I'm a lawyer, but if you just get the common cold, common flu, common headache stuff, it's going to hard to show a causal connection to work. Measles, I don't know, maybe that's a fun one to look out for. So if you guys are really interested in work comp litigation, keep an eye on that. I actually might start a Google search for that, a Google keyword alert. Pre-existing conditions, generally not going to be covered. But again, as we noted, if a work injury or illness aggravates a pre-existing condition, then that, they're going to be covered until they get back to where they were before the aggravation. Ordinary diseases of life, in general, cancer, diabetes, stuff like that. That's not going to be covered. I did mention, though, mesothelioma, right, where people breathed in asbestos fibers. If you've ever watched TV, I don't anymore, but if you've ever watched TV and say, have you been injured at work? Mesothelioma, blah, blah, blah. Those are going to be, where you can show a causal connection. Showing that you have lung cancer, it's going to be hard. For example, my grandpa, he died of lung cancer. My grandpa never smoked. He worked at a duck farm. The duck farm had lots of grains and fine particulates floating through the air, which could cause lung cancer. Downside is my grandma also smoked. So how do we prove that it was the particulates from the duck feed and the duck manure and the shavings and the bedding that caused his lung cancer, as opposed to being, living in a household where somebody else smoked and being exposed to secondhand smoke? So it's going to be unlikely that you can really tie it to a particular incident. This is a fun one, especially in Wisconsin. Injuries from intoxication, alcohol use, and drug use at work. So voluntary intoxication is not a defense, is not helpful for employees here. So if an employee decides to intentionally be intoxicated, it's going to be considered sometimes misconduct, sometimes illegal activity, depending on what substances they're on. And at this point, this kind of severs employee responsibility. I do remember some cases I've seen where people were injured, but they're severely intoxicated. And so the argument was this voluntary intoxication lets the employer off the hook. And so they don't have to worry about coverage. Work comp will deny it, and that's something they'll fight. Finally, self-inflicted injuries. So if an employee does something stupid and hurts themselves, if they take a nail gun and see, I wonder if this can shoot through my boot, and they shoot themselves in the foot with a nail gun on purpose, that's something that's not going to be covered. Again, that's something that severs injury or severs liability for the employer. And contrast that with an employee accidentally pulls the trigger and it goes through their foot, right, on a nail gun. That's an accident, but if they purposely do it to see what happens, then that intentional act, as with most things regarding insurance, intentional acts are not going to be covered by insurance, and so they're going to lose coverage. All right, OSHA. This could probably be a seminar in and of itself. OSHA record keeping and reporting requirements are different from state law. You have to comply with both. OSHA rules, generally speaking, that employees with 10 or more employees are required to keep a record of serious work-related injuries and illnesses. On the state side, under state work comp laws, generally employees must keep records, details about workplace injury and illness incidents, employee information, and medical treatment received. So work-related injuries are still reportable to OSHA even if your work comp insurance denies the claim. Overall, with the OSHA rules, all employers are required to notify OSHA when an employee is killed on the job or suffers a work-related hospitalization, amputation, or loss of an eye. Fatality has to be reported within 8 hours, and an inpatient hospitalization, amputation, or eye loss must be reported within 24 hours. So even though OSHA may have something to say about your work comp safety policies, and state laws may tell you what kind of coverage you need and what the rates are, OSHA, work comp insurance, and state work comp laws are all completely separate. So don't assume because you have checked one box that you've checked all three. Follow all rules on your safety mandates, work comp insurance, and OSHA reporting to ensure that you are compliant. I kind of touched on this next slide earlier about disability discrimination. The ADA prohibits refusing to hire or terminating an individual with an illness or impairment because you feel possible work comp injury. Remember, I used this example earlier when I said somebody wanted their prospective employee to sign a waiver to waive any coverage for any back injury that they might incur during employment because they had a history of back injuries. If you believe there's a direct threat to the safety of an employee or others, then you have to go through the ADA interactive process to figure out whether or not there is a direct threat and whether or not we're in trouble here. You should not think, you might think, but you shouldn't act on it, that this is a work comp injury waiting to happen and get them out of here. Instead, you're going to need to go through the ADA process to get more medical information. For example, an employee with a back injury who had surgery and you believe is a direct threat to safety, you go through an interactive process and decide whether or not they can safely perform the functions of their job without causing a threat to themselves or to others. If an employee has a healthcare provider and that healthcare provider says the employee's condition is not a risk, in general, you have to go with that. There are some exceptions for when you can get second opinions and stuff like that. Very rare that that's the case. I've been doing this 20 years. I can think of 1 or 2 times I've seen it, over 20-some thousand clients. So it doesn't happen very often. And it's okay to ask the applicant to show you how they would perform the job before they hire. So if you make a post-offer medical inquiry and the applicant discloses an injury, you can ask them to show how they would do the job to see if they can do it safely. This practice is acceptable under the ADA. Just make sure that you talk to us before you do it. And if it looks like they can't do the job safely, then you can rescind the offer. Again, there's a bunch of hoops to jump through with this medical inquiry stuff, so make sure you ask us about it before you do it. You can also require employees to report medication that may affect their ability to perform the job safely. But again, you have to go through the interactive process under the ADA. And finally, on this one, you think about an employee that came back after a work comp injury. They might now have a disability. That means you have to look at providing a reasonable accommodation and whether or not that means continuing to provide light duty or some other accommodation, or whether or not they can even perform the essential functions of the job at all. One key note is that you cannot say that an employee must be 100% healed after a work comp injury or they won't come back. And you also can't really set a time limit on light duty if your company has the ability to provide it without it being an undue hardship. I think this is our next to last slide here, is no retaliation. You can potentially terminate an employee who is receiving work comp benefits or who has filed a work comp claim. It's risky, however, and timing usually makes things look bad. The general rule is you can fire anyone at any time for any reason or for no reason or even a wrong reason, as long as it's not discriminatory or otherwise prohibited by law. And here, one of the examples would be that's prohibited is you cannot terminate an employee because they filed a work comp claim or because they're receiving work comp, even if that work comp claim was denied. Termination must be shown. Termination must be shown to not retaliate to the work injury or work comp claim. For example, an employee who was injured in a work-related fall, filed work comp, received work comp benefits. If the employer investigation showed the employee was stealing funds from the company, that employee would likely be able to be terminated without running afoul of the work comp laws. The termination here would not be related to the misconduct of the work comp issue. The fall of the work comp issue, and would be related instead to misconduct and law breaking. So it's not related to the work comp claim. So in essence, a termination reason must not be related to the work injury or work comp claim. It's better if you have documentation about the issue that occurred well before the injury and that you were thinking about doing something beforehand. Otherwise, it becomes risky. If an employee does file a claim, a court or other government body is going to look at the temporal proximity. In other words, how close was the firing in time to the work comp claim? The closer it is, the more likely it's going to be deemed to be retaliation for filing the work comp claim. And as I noted, an employee can win a retaliation claim even if the claim was denied. So retaliation has its own set of legal standards that's over and above or completely separate from whether or not a claim for work comp is approved. Retaliation, in short, is an adverse employment action against an employee for engaging in legally protected activity. Here, legally protected activity would be filing a work comp claim. So even if work comp is denied, the retaliation could go forward if they meet the elements and you don't have a legitimate non-discriminatory business reason for your adverse employment action. I think I noted this earlier. Don't investigate work comp claims by yourself. Let your insurance company do it. They either find merit or they don't. That's all it is. You are not responsible for sending out private investigators to spy on your employees to determine whether or not they really hurt their back and terminating them because you think they're faking. That's what the insurance companies do. They're good at it. Trust me, they don't want to spend any more money than they have to. And so if there's a way to deny a claim, they will deny it. All right, I think this is our last slide here. Perfect timing. Just some general overview on how you can protect your costs. Implement, number one, implement a cost reduction program. You can do this sometimes through pre-employment screenings of applicants that have physical nature jobs to make sure that their job-related skills and physical abilities align, such as whether the applicant for a job that requires heavy lifting can actually perform the heavy lifting without injuring themselves. Again, this is subject to ADA rules and ADA procedures, so make sure if you're going to do this that you're comply with all that. And your work comp carrier might have some programs or resources to help you out with this too, because again, they want to reduce claims as much as possible. So the more they can head off claims before they even begin, the happier they're going to be. Number two, train your employees on safety. Implement a safety program that provides for regular meetings to discuss workplace safety, such as accident prevention, first aid, etc. Make sure that you give out written materials to reinforce the safety training and communicate about hazards in the workplace. Some of these are going to be more important for some jobs than others. Forklifts are a general bane of safety existence as opposed to an office clerical position. But still, there are issues with office clerical, such as carpal tunnel, posture, stuff like that. And so it's probably not going to be as big an issue in the office, but it's still an issue. Train your managers and supervisors so that they are aware of proper safety procedures, proper procedures for reporting accidents, and so on. Make sure that your supervisors understand how to get employees medical attention if they need it to ensure employee safety and minimize injuries and related costs. Instruct supervisors or have someone trained on the proper techniques for gathering information from the employee and other witnesses to accidents and injuries. The initial investigation is going to be the best opportunity for an employer to figure out what happened. It's where you develop the facts to defend against a work comp claim, and where you can gather evidence that can be used in later proceedings. And again, the best stuff comes right away when you're figuring out what happens. Number four, know your work comp policy. Understand the correlation between current experience and future workers' comp premiums. So how your experience rating affects you. Identify who's responsible for attorney's fees and defending work comp claims, and determine whether or not those fees are reflected in your experience rating. Figure out who pays for everything, from medical examinations to surveillance to everything else related from the work comp claim. Make sure you understand who's responsible for that, and determine whether or not you have any input in selecting the attorney to defend the case if you really care. Number five, look at your claim history. Study your work comp history to see if there's any patterns in injury type or frequency. Determine what the most common injuries are, and see if there's a way you can create a safety program, or that your insurer can help you come up with a program to avoid these injuries. And finally, take a look at your claim management practices. Consider possible courses of action for each work comp claim, including what happened in terms of reporting. Was the reporting done on time? Do you know about light duty? Is light duty an option for your workplace? Do you have light duty options? Do you have criteria, et cetera, and who interacts with the insurance company? Who files the first report of injury notice? Who is a contact with the insurance company to determine what the next steps are in terms of the claim procedure? All right, that wraps it up for me with a fun hour of work comp. So how we can help, ask us. We stay on top of work comp issues, common area of question for us. Our weekly newsletter provides updates. If you are already a subscriber, make sure you check out the newsletter every Tuesday. If you want to subscribe, shoot us a message at info at myhrcounsel.com. And we can advise you on the best way to handle some difficult work comp issues. We have expertise and a lot of experience in this area. Again, if you have questions, please shoot them through the portal if you're a current MyHR Counsel subscriber. If not, you've got questions about subscribing, emails down there in the left-hand corner, info at myhrcounsel.com, and we'll see what we can do to get you guys signed up. Thanks much.